Clients are often upset when they come to see me about a litigation matter. Someone has done them wrong, they are angry and want something done about it right now. I understand. Nobody comes to me about a lawsuit because they are happy. However, it is rare that a court will take any action on an emergency basis. In most civil litigation, emergency relief from the court, if available, comes in the form of a temporary restraining order, or a TRO. There are several requirements. Under the law, a TRO can be granted without the participation of the opposing party. This is referred to as ex parte. However, most judges are reluctant to issue an order ex parte absent a compelling reason not to give notice to the other side and allow them to appear. A TRO requires that the plaintiff plead facts and a legal basis for a claim for permanent relief. For example, two parties might assert claims to a building, and one of them is preparing to demolish it. The claimant seeking a TRO could file suit for trespass, which may satisfy the permanent relief requirement. The party seeking the TRO must convince the court that they are likely to be successful in the lawsuit. This likelihood of success is demonstrated by sworn pleadings or affidavits explaining the merits of their lawsuit. In our example, if the claimant has what appears to be a valid deed to the building, the court might conclude that there's enough evidence to stop the demolition. Lesser evidence, such as an oral promise regarding the building, will likely not satisfy this requirement. A TRO requires evidence of an imminent injury that cannot be remedied by money damages. This is often the hardest element to satisfy. In our example, if the demolition crew is scheduled to be on site in 60 days, that is not imminent. If the bulldozer is on the property and the crew is about to knock the building down, then the injury is imminent. Permanent damage to real property satisfies the irreparable element. However, loss of money generally does not. The purpose of a TRO is to preserve the last peaceable, non-contested status which preceded the controversy. So in our example, the last peaceable status may be that both parties have competing claims to the building. Those claims need to be resolved in trial before the building is destroyed. The court might conclude that preventing the demolition preserves the status quo. In contrast, if the party seeking to proceed with demolition asks for a TRO to allow the demolition, it may be difficult to convince the court demolition is the last peaceable, non-contested status. In state court, if the court grants a TRO, the order expires in 14 days. To preserve the restraint longer, the parties must participate in a temporary injunction hearing prior to the expiration of 14 days. This is a contested mini-trial with live testimony. As a result, contested TROs and temporary injunctions can dramatically accelerate the cost and burden of a lawsuit. A TRO is called extraordinary relief for a reason. The court must be satisfied that each of these elements has been met and that there is a compelling reason for the court to intervene on an emergency basis. In my experience, the majority of cases do not justify extraordinary or emergency relief.